Okay, everybody, we're going to get started. Thank you all for coming to our second BookIT book talk of the semester. We have the pleasure of hosting one of our alums, Stephen Johnson, who will be speaking about his book today called Guide to Intellectual Property, What It Is, How to Protect It, How to Exploit It. And I took a quick look at it. It looks like a very handy reference book for IP in all forms. It's published by The Economist, I should mention. A little bit of background for Stephen. His current work focuses on intellectual property from a business perspective, which is the nature of his book. He consults for a U.S. nonprofit, One Mind, which focuses on intellectual property and other policy issues affecting neuroscience research. Previously, Stephen Johnson practiced as an IP attorney for the law firm of Kirkland & Ellis, and he practiced for more than 30 years. He was named in 2015 as one of the world's leading IP strategists by Intellectual Asset Management in its IAM Strategy 300 survey. And before law school, he studied genetics at Cambridge University before becoming a solicitor in the United Kingdom in 1982. With that, I'll turn it over to Stephen. He'll speak for about 30 minutes and then entertain your questions.
Thanks very much, Ed. And thanks very much to Chicago Kent for inviting me here to speak today. I think it's quite lucky in a way that I went to Chicago Kent and that I've written a book which is really intended to be a guide on intellectual property for business people, because Chicago Kent is, I think, pretty unique in terms of its program focused on intellectual property management and markets. I'm not aware of another program like that, and in fact, I know from living as I do in the Bay Area and having a son who's just completed an MBA that intellectual property is really not a part of graduate business education, and I think that's a huge hole. And one of the reasons why I decided to sort of embark on the foolhardy task of writing a book which business people could use. And let me just talk a little bit about Chicago Kent. As Ed said, I started out life as a baby patent litigator in England, and in 1980 to 82, all the patent litigation in England was between large American companies. Was at that time, patent litigation in America was remarkably ineffective. It was regionalized between the various circuits, who had entirely different views as to whether patents were a good thing or a bad thing. And there was a heavy overlay of antitrust law on top of it, which meant that patents were treated with suspicion. And it was only in the start of 1983 with the formation of the Court of Appeals for the Federal Circuit, which, as you know, is a sort of specialized appeal court for intellectual, well, some patents and in some instances other intellectual property, that the system, as all you know it, started. And so England used to be used as this kind of proxy war between large American companies like Dow Chemical fighting with other chemical companies, where they fight their patent litigation in England, and depending on whether they won or lost there, then they'd resolve matters between them throughout the world. So I decided I'd come over to the US and spend a year, go back to England and be a better lawyer in England. And through a huge stroke of luck, I was originally going to go to New York, huge stroke of luck, I ended up coming to Chicago, and then deciding I was going to stay, and decided to get qualified as an attorney, and I came to Chicago Kent to get my JD degree. And I was used as a teaching aid by Professor Spack, who was delighted to have someone with a British accent in his class, and he'd say, Steve, because he knew I hated being called Stephen. So I hated being called Steve, I like being called Stephen, that was how I was calling him. He'd say, Steve, you're the man with the words, you're the man with the big vocabulary, what do you think about this? So Professor Spack used me as a teaching aid, and then the class I look back on was with Professor Gerber in antitrust. And that was a class which, because the main limit on what you can do with intellectual property is competition law and antitrust. And that was one which has stood me in good stead all the way through to writing the chapter on antitrust in this book. It was just a fantastic course. So I look back on my time at Chicago Kent as with great fondness. It's also fair to say that going to law school a second time is more fun than going the first time, because you kind of have a clue as to what's going on, because you've been out in the world, and so it's actually sort of much more, in a way, much more intelligible second time round than its first time round. So what was the purpose of this book, and how did it come about? So I was working with a client who had an idea that what he wanted to do was lend money using patents as collateral, as security. In other words, you get a mortgage for a house, the house is the collateral which the bank uses to secure the loan. So he wants to make large loans on the basis of intellectual property. He was already in that business, and he was working with other lawyers, and then we got started, and I started talking. I said, well, you know, on average, 50% of patents get invalidated one way or another, 50%. So you really need to think about it. I said, oh my God, no one has ever told me that. I had no idea. Why is no one in the business of lending on the basis of collateral? And I thought, very few lending on the basis of patent collateral. I said, well, very few people are. And I began to think about that, and it made me realize that for the business community, intellectual property is kind of opaque. They have no real idea what it's about at all. So I decided that I would write a book and try and focus on intellectual property in a business context. So every book has to try and explain what the different forms of intellectual property are. So I covered up the main forms of intellectual property. But then I try to deal with it in the business issues which come up. So one thing which is in this book, which is rarely in books on intellectual property, is cost. How much does it cost to file for patents all over the world or to have a trademark portfolio? What are the costs associated with intellectual property? Hugely important to business people, comparatively rarely discussed, although right now, and I might talk about this later, we're in a mood of anti-patent sentiment, at least in the US and the UK. So just this past week, the Financial Times published an article basically saying patents are ludicrously expensive to obtain and litigate. We should just, retool the entire system. A lot of talk about that at the moment. Cost, ownership. One of the things I found in my career as an intellectual property lawyer was there's a huge number of disputes over ownership. Ownership is very rarely covered when people talk about intellectual property. And my experience is that the default rules normally defeat business expectations. What do I mean by that? If I asked one of you to write a paper for me on intellectual property, and I paid you $1,000, who ends up with the copyright in the paper? You do, the person who wrote the paper. The default rule is that the copyright is owned by the person who creates something, same for designs, same for patents, same for logos like this one, unless there's a contract assigning rights or unless you're an employee, where it's called a work for hire. Then, in business collaborations, people work together. If by working together, they don't actually destroy the intellectual property because they don't keep it confidential. If there is an invention or whatever, the default rules are joint ownership, which essentially means normally that no one has any rights they can enforce alone. So again, it tends to defeat business expectations. So I cover ownership. Then I try to look at what does intellectual property do? So how does it protect sales? That's really what people are looking for. They're looking for a barrier to entry to competition. That's what business people are focused on. how can my patent prevent others from competing with me? If I keep something trade secret and someone tries to steal that, can I stop them to maintain that trade secret? If I write a book, can I stop someone copying it? Just a word there on the limits of intellectual property in the world of the internet. If you do a search and you do the entire search of The Economist Guide to Intellectual Property, so you're looking for the entire phrase of the book title, you will find that about ranking number 4 on Google, that someone has gone to the trouble, I know not why, but I suspect he has some grudge against intellectual property, he's gone to the trouble of scanning the entire book and putting it up free on the internet. And interesting enough, it's been done in a quite sort of difficult to get at format, because there are websites like Scripty, which are a little bit like YouTube and so on, and so they have both legitimate content and illegitimate content, but they have a machinery in the website called what's called a takedown notice. If you own the copyright, you can write to them and say, take down. My book is up on a site which is where people get open source software to create Wi-Fi hotspots. And for some reason, as far as I can tell, someone has put this book on some database accessible from some local Wi-Fi spot somewhere, which you can download through the internet. I haven't gone into it too much because I don't want to have my computer infected by whatever goes with this clearly sort of anti-intellectual property rights stance. I have to get to my local library and use theirs and try and download it when I have the time. So I have a chapter on the internet, but for many people, the internet has been, as well as a boon, it's been a force which has completely undermined pre-existing intellectual property regimes. First of all, in music, then as bandwidth increased in film and TV, and then in what I call hard book publishing. So looking at IP from an internet perspective is immensely important to business people. So how does IP protect sales and when doesn't it? Then how can you use intellectual property to generate revenue? For a business person, traditionally they looked at generating revenue through licensing. The whole of publishing is essentially on a licensing model. So copyright in this book rests in me for the text and for The Economist for the whole book. And the US edition is published through a licensing deal between The Economist in England and a publisher in New York, who then sells within the US market. That's making money off IP through licensing. More recently, as you may know, there's a whole phenomenon grown up over the past decade of people using intellectual property patents in particular to gain revenue through suing companies. It's what people call them patent trolls, if they're at the bottom end of the market, or non-practicing entities or patent assertion entities. Whole industry growing up where people are simply using patents as financial assets to try and extract royalties and settlements from people whom they allege are infringing the patents. It's led to a sea change in attitudes about the patent system over the past 10 years, and to my mind, a lot of collateral damage, because the Supreme Court has waded in to this debate, initially with the eBay case, which you may know from civil procedure, that basically says that patents aren't special property, that you get an injunction, you have to have all the stuff you've learned about the civil procedure about irreparable harm and balancing the equities, blah, blah, blah. Whereas it used to be before eBay, had a patent, you had an infringer, you got a judgment, you got an injunction. The Supreme Court doesn't believe in what some people call patent exceptionalism. They put patents into the mainstream of the law, but along the way, and this gets to my role in neuroscience, as well as smacking around the world of software patents and technology patents, so they're business method patents, so they're much, much harder to obtain, or if you have a patent, they become invalid. The Supreme Court has waded in on what it called laws of nature and so on, which actually means that nowadays, just at the moment, as we're in the era of personalized medicine when you can have a diagnosis which is personal to you. You can see whether you're going to react well or badly to particular drugs or combination of drugs. Just at that moment, the Supreme Court has thrown the whole area of patenting in diagnostics, which rely on either laws of nature, such as if you have a BRCA mutation, you're more likely to get breast cancer or not, or you try and protect diagnostic kits by having patents on purified samples of human genes. Whole area thrown into disarray. It's because the Supreme Court has just become worried that in a sense you're able to patent anything, and they've sort of formed a policy conclusion that's a bad thing rather than a good thing. So I think the whole patent troll phenomenon has just made an enormous impact on the patent system within the US, and people have tried to change the system. Legislation has been passed making it easier to invalidate patents. So during the course of writing this book, which took way too long, the patent chapter probably had to be revised 5 times. And so the first draft of the book said that, generally speaking, if you're based in Europe, you should remember the US, because it's often easier to get a patent in the US than it is in Europe. The final version of the patent says, if you're based in the US, think about Europe, because even if you can't get a patent in the US, maybe you can get one in Europe, where the rules on diagnostic tests, for example, have not changed. So what else do we talk about? Raising revenue using intellectual property, the market for intellectual property. So here at Chicago Kent, we have a degree program focused on the IP market, which is very forward-looking, because a market as such has only really existed within the past decade. It used to be before that large-scale purchases or sales of intellectual property or deals that were entirely driven by intellectual property were few and far between. Then valuation. It's a very bizarre thing. I was just talking about this before this presentation with Dean Krent, that there are very few established ways of valuing an intellectual property right. And the phrase I use in the book is intellectual property valuation, while not in childhood, is still at least in adolescence. In other words, it's an awkward business. It's partly because of the nature of intellectual property. Because if I tried to sell you a portfolio of patents which cover how 4G phones work with each other, it's actually worthless to you. It wouldn't be worth anything. But if you sold it to a new entrant to the market, a telecom company from Asia, it'd be worth a lot to them, because they can use it, and they can use it to bargain with others for cross-licensing. So intellectual property valuation is immensely difficult, and even in areas which you think ought to be understandable, like valuing brands. So each year, the 2 big branding agencies in the year produce, the world's top most valuable brands. You've probably seen these. It's Google's up there and Apple's up there. But the actual valuations these 2 rival consultancies provide are tens or even $100 billion apart on what they think the Apple brand is worth. In other words, what portion of the profits of Apple is attributable to the brand versus what portion is attributable to all the other assets that Apple brings to the table. So valuation is difficult. A chapter which is really the sole remnant of the original idea I had about writing a book, which is using intellectual property as collateral for finance. So borrowing money and then the bank takes a security interest in patents, or other complicated structures like many fast food companies issue bonds to the public where the security underlying the bonds and the payments is the brands, and then the streams of income, the royalties coming in from all the franchisees all over the world. And then finally, building an IP strategy. And so some people ask me, well, what did you learn from writing the book? And the the conclusions I learned was, first of all, number one, I've got a strong suspicion that the most valuable intangible asset held by many businesses is not intellectual property at all. Does anyone here have an idea as to what that might be? I'm from the West Coast, working in Silicon Valley, so I think there's an intangible asset which is more important than patents, copyrights, trademarks, trade secrets, designs, whatever. I think it's personal information. So there was a study last year where someone calculated that the information, how many people are on Facebook? Quite a lot, probably most of you. I'm too old. But it was a calculation that the information which each of you willingly give to Facebook, once you ignore the privacy policy and ignore how they use your data management, it's worth $27 per person to Facebook, which doesn't sound a lot until you realize that there's over 1 billion people in the world using Facebook or something now. So personal information is not actually, it's hard to say what it is. It's just a collection of information, because it isn't actually confidential. People can find out where you live. People can work out what you buy. People can probably find out a lot about your information. It's not confidential, it's just the mass agglomeration of information which is so valuable and which is so important, because there's this phrase which a number of you have probably heard, which is attributed to any number of business people in the 19th century, and the phrase is, 50% of my advertising budget is wasted. The trouble is I don't know which 50% it is. And the goal of targeted advertising, which uses personal information, is to be able to personalize and direct advertising. There's a guy I know in San Francisco who works at a startup, and what he's trying to do is to enable any advertising that comes to you either through TV or through internet streaming or whatever it may be, where you find yourself looking at ads, to be pretty much localized to the street where you live. So it will be very, very directed at what they assume to be your particular demographic. Anyway, strategy. So there is a lot of sophisticated intellectual property strategy dealing with innovation and patenting. In other words, you may obtain patents to try and protect features of a phone. I'll talk about Apple here, because I think Apple probably has the best IP strategy in the world. So Apple has thousands of patents and other intellectual property rights. So it has patents which it has obtained on features of its phone, such as the slide to unlock and so on, which it is trying to assert against competitors. The goal of those patents is to stop competitors from selling rival products with similar features. Then it has, and it was a real originator in that regard, it has thousands of patents on its designs, the meticulous design of the screen, of the tiles on the screen, and so on. Then it has vast numbers of other patents covering various aspects of telecommunications and phone design and so on. And really, those don't cover consumer features. They're not why you or I might buy the phone, but they're really there for trading. They're to assert against competitors who may assert patents against them, or in the world of telecoms, which involves everyone in this world eventually having to cross-license most of their intellectual property to each other. They have vast portfolios for those of trading with each other. So there are all these different ways in which you can create and use patent portfolios. But my conclusion was, at the end of the day, having written this book, that for most businesses, intellectual property strategy can be pretty simple. And rule number one is own what you create. And I gave a presentation at the business school at Cambridge in England. For those of you who either remember or like 80s music, there's a song It's my best friend. She's my best friend's girlfriend, but she used to be mine. The title of my presentation was to this entrepreneurship class, it's my best friend's patent and it used to be mine. And the issue there was that in these early stage collaborations and generally throughout business, as I said earlier, people never sort out the ownership. People never document the relationships. And you can avoid so many issues in intellectual property if you just make sure that in your business you own what's created for you, or that you create yourself. You have the right agreements and so on. It's basic housekeeping. So that was rule number one. Then rule number two, and then if you own intellectual property, if you have the right to file patents, you can decide whether you're going to file a patent or not. Patents are expensive and complicated and subject to challenge. But copyright is wonderful. If you own copyright, then such people knocking you off on the internet, it's done. You write the thing, it's written for you, you own it, you don't need to register it, or you do in the US for various complicated reasons, but 99% of the world, you're done, you've got an intellectual property right. Same for in many countries which have unregistered rights in designs. You're done, you own it, you're done, you don't have to file anything, you don't have to pay any more money. So then the other area is all businesses need to be concerned about personal information. Information about their employees, information about customers, information you've obtained under license from third parties. We've seen this past week that the EU has blown apart one of the ways of sharing information between the US and Europe, so-called safe harbor. Personal information is a concern for all businesses, domestically and internationally. California is a leader in state legislation protecting the privacy of individuals. So pretty much all businesses have to focus on security of information and confidentiality. So if you round that up, you're not only ensuring that you're in compliance from a regulatory perspective, but you're also protecting your own confidential information that may be a competitive advantage, whatever the secret source is in your business. Then the next issue is you want to look after your brands, because for most businesses, your brands are the most important thing. At the end of the day, for all the thousands of patents and the tens of millions of dollars spent on patent litigation between Samsung and Apple, Apple still has a stronger position in the marketplace, I believe, because it has a stronger brand. And its brand is pervasive and uniform all the way through, from the phone to the logos to the packaging to the store, and they have trademark registrations on their store layout with the Genius bars and so on. So they have covered everything. So look after the brand. Many businesses don't look after the brand, and the brand is, I think, far more important than other forms of intellectual property. And brands are actually intuitive for business people. And then the final thing is, don't just look after your brands or where you've got a right to file for intellectual property. File for registration or patent, because that in essence tells the world that you own it. The world of intellectual property depends on priorities, who files first, generally speaking. So I think many people found the strategy section of my book disappointing, because I think for 90% of the businesses who aren't involved in the world of huge patent portfolios, you can solve a lot through ownership, confidentiality and security, looking after your brand, and filing for what rights you have. So just before we open up for questions, I want to take 2 minutes on an interesting issue which I think is coming up, which is, I talked about coming to the States at the beginning of '83, the founding of a new court. And essentially there was a bull market in intellectual property rights all the way through from 1983. Patents were enforced, people got more interested by intellectual property, and all of a sudden we are now at a point where, because of the phone wars, which business people regarded as wasteful and only benefiting the lawyers, I think it's probably true, and the actions of people asserting patents just for financial gain, there's this sudden movement against patents. So one thing that's come up for me in the past 2 weeks is about 2 to 3 weeks ago, The Economist magazine came out with this opinion piece saying that the entire patent system should be rejigged. And so that wasn't my position. And this to explain, The Economist published this book is one of a number of guides which are aimed at business people. So they're aimed to be essentially a practical guide for business people rather than a policy piece. And so suddenly, an example of what happens in the intellectual property world, my name is associated with the Economist brand. The Economist brand is suddenly associated with a radical view on patents. And suddenly people are saying, are you Stephen Johnson, the intellectual property patent communist? It's essentially what they're saying, who wants to tear the system apart. But we are at an interesting point where, for all of my professional career, up until this past year, so 29 years, there was really a belief that patents and other industries drive innovation. Now there's this tide flowing the other way saying, wait a minute, lots of people say, don't patents and intellectual property rights perhaps retard innovation? And just with patents, my one point on The Economist, I think patents do two things. One, I think they may act as an incentive to innovation, but two, they're a way of commercializing technology. So universities, in essence, provide their technology to the outside world in many ways through patent licenses and so on. So what the IP world does, as well as running incentives, is it provides a structure for people to do deals. And I think that's something which critics of the patent system ignore. They do have two functions. One is incentive. The second is a structure to do deals so you can license technology and provide it to others. So there's a lot of debate right now. I think it's a collateral effect, as I said, over the activities of so-called patent trolls. But it's certainly a very interesting time to be in the intellectual property world. So let me now just turn this over to questions. And it can be on anything. It can be on everything from law school through to what I did as a practicing lawyer, the book, or whatever.
I had a question. If you could just share with us a little bit about what your role is with the consulting for the charity about.
Oh, that's great. Yes. So that's a very interesting role that I stumbled into. So in the world of academic research, data is, the question is, do researchers share data or not? As you know, we now live in the world of big data, and strongly held view that if you aggregate lots of data together, you can gain insights which are not available just looking at smaller data sets. And that's certainly been the one mind that the not-for-profit has a focus on mental illness and brain illness. And certainly the genetic basis of conditions like autism and schizophrenia only became available when you got up to sequencing above 100,000 people who either did or didn't suffer from disease. It's only when you have this massive number of people you can start to see which genes were implicated again and again. Now, the problem with most academic research is that it's in the science world, it's driven on what I think is a very old-fashioned model. It's the individual researcher sitting in his or her laboratory, and by themselves they come up with the cure for cancer or whatever it is, or the cure for schizophrenia. And researchers tend to hoard their data for many, many good reasons. First of all, they mine their data for papers. And papers are the currency of the academic world. If you publish in a high-impact scientific journal, then that may get you tenure at your institution, it may get you promotion, but most importantly, it will get you grants. Because in most US universities, if you're a researcher, you really got to pay your own way. You have to get grants from the government or elsewhere, and papers published in high-impact journals are one of the ways to getting grants. So people hoard their data. So that's not good for creating large data sets. So ideally, you'd like to be able to go to every single researcher in the area and say, bipolar disorder and say, let's lump all your data together and then we can get some real insights onto this. But people don't like doing that, so part of my job is working with the incentives within the system to try and come up with ways where people might be willing to do that. And it could be things as simple as people don't get paid to put their data into a form that can be used by others. All of you in study groups will know this problem, which is essentially your data from the lecture are your notes. And they're really hard for other people to read. So if you're a dutiful member of the study group, you actually sort of go back afterwards and you make them legible and meaningful, and then you share them, for which actually you get no compensation other than thinking you're a good human being. So for scientists with big databases, it's a nightmare. You have to do a lot of work to get these into a coherent format. And then you get back to the reward system. Right now, there's very few rewards for scientists to work in teams. In the NIH criteria for awarding a grant, nowhere is it good guy or team player. You know, they do subtly try and penalize people who are notably bad actors and who won't share things that it's necessary to share, but generally they won't. So it's trying to alter that incentive system through convening conferences, trying to structure alliances, trying to get scientists to share so they see there aren't bad results, there are good results, actually get more papers out of it, there's more stuff to look at. The other side of the job is policy work. For example, there hasn't been a good new drug for schizophrenia for 50 years, since the 1950s. And those drugs in the 1950s were found through accident, not through design. So how do you incent a pharmaceutical company to invest in a really risky area? And so that comes down to the state of the patent system. Is the patent system enough, or do you need more incentives? So parallel to the patent system in the pharmaceutical world are things called data exclusivities. That's the reward for doing a clinical trial that may cost hundreds of millions of dollars. You get a certain period of time when no one can put a competing product on the market, regardless of whether your patent is good or bad. And so the question is, for high-risk diseases, should you actually have total market exclusivity to encourage companies to do things that they're not doing right now? And the other area would be, what's going to happen to diagnostics now the Supreme Courts have blown away most of the patent protection? What I can tell you is that completely contrary to the organizations that were responsible for the decisions which have limited patent protection for diagnostics, it's led to an immediate, in my experience, immediate slowing in the velocity of information, as opposed to the expected increase in speed of dissemination of knowledge as people are patenting. Because to the extent that new potential diagnostic markers have been found by anyone in the private sector, right now they're holding on to that information rather than disseminating it as they try and figure out what to do about the patents, where they can get a patent in some way revolving around that marker. And the same is true for the lesser. Some universities have given up on patenting, others are also in a similar position of data hoarding. So you get lots of unintended consequences when people do things for good reasons. So that's the other side, is sort of policy on the patent and exclusivity front.
Okay.
I'm glad you brought up the Economist article, because I was hoping I could ask you a little bit more about it, but
Sure.
you answered my first question, so I guess my next question would be one of the...
I can talk about it if you want.
Yeah.
Yeah.
Well, one of my questions is regarding one of the recommendations
Yeah.
that the Economist gave, is, there should be an easier way to challenge
Yes.
patents. My understanding was with the American Defense Act that would be the inter-party
Yes.
reviews, the post-grant proceedings. So was the Economist not? Well, you weren't involved with the writing, but
No, so I think on that one, I think that procedure now exists in the US. Yeah, so that's, for those who don't know, it's this new procedure came in 3 years ago now, I guess it is, where if you are sued for patent infringement in district court, you try and invalidate the patent, you actually have to prove that by clear and convincing evidence. The patent comes with a presumption of validity. This new procedure was brought in called inter partes review, and there's another one which covers business methods, and they've been, when the point of view of patent challenges, been really a successful means to invalidate patents. And just in the past month, it's become apparent that the Patent Office doesn't really care about the motives of the person who challenges the patent, because there's a hedge fund guy down in Texas called Kyle Bass who's filed challenges against pharmaceutical drugs, and people thought somehow the Patent Office would just say, no, you're clearly a bad guy, and you can't file it. He said, no, you can file. So this is up and running, and people who are pro a very strong patent system refer to IPRs as patent death squads. That's what they were called by the former Chief Judge Rader. So I think the job's done in the US in terms of an easy way of invalidating patents. And I actually think, even though I'm a very pro-patent person, my clients are on sufficient. It used to be a horrible thing when you were sued under what was clearly a dud patent. It was going to cost you, $1 million, $2 million in legal fees before you could get out. That's a bad thing. So even though I'm really philosophically in favor of strong patents, I'm a supporter of the IPR proceedings. I think it does weed out bad patents, because the interesting about the Patent Office is, and this is sort of a good little exercise in economics, most patents are never used and are worthless. So estimates vary, but say 85 to 90% of the output of the Patent Office never gets used, it's useless, never litigated, probably never licensed. So how much effort should the Patent Office put into examining each one of those patents? Some people say actually you should leave it to the market. It would be hugely expensive to have a thorough look at a population of, say, have only 100,000 patents it is a year, most of which are completely irrelevant to anyone. There's an argument to say you should look at patents after they've issued, and the market should decide which are important or not, which, interestingly enough, in most countries of the world is how it works with trademarks. But in the US, our trademark office, if you file for Cadbury on chocolate, the US trademark office will kick you out. But you could actually file for trademark Cadbury on chocolate in many European countries, or for a community trademark, and the trademark office would give you the trademark, but it would say, oh, by the way, this Cadbury has 1,000 registrations in this area, and they write to Cadbury and say, hello, this doofus has filed for Cadbury, but then it's up to Cadbury to challenge the trademark. And so in the patent world, there's an argument, lots of people say there's a huge problem with the patent office. On the other hand, a lot of what the patent office does is review worthless patents. So I think a strong post-grant challenge system is actually a good thing, because it's sort of an economically rational way of dealing with all the dud patents that are issued.
Are you at all concerned with that, the recent cases, I don't remember in what district or court, let's say that the post-grant processes are unconstitutional because it's not an Article 3 court taking away your property, but an administrative court?
That way, I think that litigation is still pending, right?
Yeah,
I think it's gone up on appeal.
Mm-hmm.
So, no, I'm not concerned because I don't worry too much about, it's just a constitutional law issue which has to be resolved. I think that, to me, the effect in the marketplace is the right thing.
Thank you.
Yeah.
Well, I do have questions about your book, but since you're here and there are a lot of students here and you have 30 years of experience, I thought we would tap into that knowledge.
Sure.
What advice would you give to our students who want to practice an IP in terms of the things that they can do to make themselves attractive to employers?
This is I would say, get exposure to intellectual property so that you have something meaty to talk about in the interview. So obviously there are after the event tonight, are going to be increasing opportunities to do some work with intellectual property on a practical level. So I would say do that, but then the hard work is you've got to do your own study around whatever it is that you did so that you don't come across as ill-informed in the interview. By which I mean, the classic, I was a hiring partner when I was in for Kirkland's New York office, when I was in office in New York. One of the classic sort of interview failures is when what you would ask is, what have you written a paper on? I say, oh, X. And then you say, well, what about Y? And the buddy goes, well, I would look at that. So it's the same with whatever you're doing in the intellectual property area. So say you're someone with a scientific background who's filing a patent application for one of the startups around here, and it's on something in the software area. You know that the person who's carrying out the interview is going to say, well, how are you getting around all these new cases on software? So my point is, you do something practical to show you're interested, and but then you back it up with some self-study. And the good news is in the intellectual property world, there's oodles of practitioner-focused material. So if it's an issue on patenting software, you can go on the internet and you can find client releases by all the law firms in the country talking about the problem, and that's so much easier than going off, studying it all day novo. So you could do something practical and have the substance to talk about the issue you're going to present it into, because people are recruiters like to look for someone who's got a demonstrated interest and then does well in interview. That's what it comes down to. Other questions?
In the budget review and post-grant review, I know you say you're not worried about it, but somebody like Calvas actually said, okay, I'm using it to show stocks, right? So I can see when I have the litigation against a patent, I can see the stock of the company go down, and I'm investing based on that. So would you say that's leading to some kind of abuse of the post-grant review?
So that's what Thomas said, yeah. So I think there's a really interesting backstory to this, which is that Kyle Bass, the hedge fund guy, is cooperating with a guy called Spangenberg. And Spangenberg is one, he's sort of one of the, careful phrasing coming up, he's one of the people who many would describe as being the ultimate type of troll. He is not popular with technology companies, and I suspect what's really difficult about him is that he's a super intelligent and talented guy. So some people say that Spangenberg is using Bass, what would the phrase be, as a stalking horse? Or he's using Bass to create the situation which will most appall Congress so that they will then repeal the IPR proceeding. So, Congress isn't going to get that excited about a bunch of software patents getting invalidated, but if it starts affecting the incentives of the pharmaceutical industry, then they may get excited and then try and limit IPR. So I think politically, that's what's going on. So the issue about IPR and pharmaceutical patents is the patents he's going after are generally speaking not patents on new drugs. They're on what some people call evergreening patents. In other words, you have the patent on a new drug, and then before that patent expires, you look and say, well, maybe we can get a patent on a once-a-day formulation. Some of those drugs are really good, because when I worked in New York, my lawyer would always give me drugs, and he says, these are drugs for lawyers, investment bankers, and homeless people, because none of you guys can actually take 4 pills a day and keep up with the regimen. So many controlled release drugs are, fantastic improvements, but some, they're marginal. So you can argue that, are those just maintaining drug prices? So there's sort of two sides to the debate. It would be, I think, extremely hard to knock out, a really original drug patent in an IPR. If it happens, then I would immediately flip and say, this has gone too far.
Any questions?
I have a
Sure.
question, if I may. It's
Yeah.
completely different from everybody in this area. As a startup company,
Yeah.
intellectual property, when you want to, so you have the idea, the concept, and
Yeah.
you need to make a prototype or something.
Yeah.
So you need to bring someone else on board to
Mhm.
engineer or design. So how do you handle that as an intellectual property before creating like a team of people and then someone actually making it who isn't you?
Yeah, so that's exactly what I talked about on that lecture. It's my best friend's patent, and it needs to be mine. It's extremely hard to do. And right now, I think there's a lot of startups, particularly in the sort of consumer-focused internet area or whatever, who are sort of, they spend their first period of time, like long it is, in kind of a free zone. Because what you actually have to do is get written agreements with all the people with whom you're collaborating. You've got to decide who's going to own it, and then they've got to agree to keep it confidential. Because if you have a patentable invention and you disclose it to third parties without confidentiality, that's going to knock out your ability to get patents in most countries in the world. So a bit of grace period in the US. Most countries in the world have what's called absolute novelty. So it's generally speaking kind of a big mess. And I'm actually going to be doing I think I'm going to be collaborating with a guy and do a series of lectures at the business school in the Bay Area. One of them's going to be on operating in this zone. Because what the IP law demands is written agreements, confidentiality, and someone else doesn't own it. The someone else that doesn't own it part comes, very often one of the people who's talking, one or more of the people who are talking about a business idea work for someone else. And they probably signed employment agreements that, inventions they make, they work for someone else and they're thinking of going out and competing. So it's where the sort of the ponderous nature of intellectual property is hard to reconcile with the speed and informality with which people operate. So this is actually one of my kind of interesting areas. So there's a service called Lexology, which enables you to get releases from law firms on areas of interest. I always look at the ones where they talk about working with startups. It's like, look, who's the person who's going to solve this problem? And right now, no one I know has come up with a good answer other than you actually need to have some simple agreements. And
For me, the area becomes very sticky because the so-called outsider who didn't think of the idea, maybe they come up with a concept that's key to everything working, and then they could then argue that that was actually an invalid proposition without their input. So how do you?
It's a difficult area.
Yeah.
It leads to a lot of. I mean, it's exactly in a way like the litigation surrounding the founding of Facebook. So I can't remember. Can anyone remember the name of the product which those twins, the Winklevosses, they had come up with an idea of a register of students, that's with whom you could communicate or kind of friend. But it didn't work the same way Facebook did. They allegedly retained Zuckerberg as a programmer for them. And during the course of that was when he came up with the idea and code for Facebook. So it's a not uncommon situation. It's also not uncommon between large companies. The only difference with large companies is they tend to sign an agreement before starting. So it is difficult to get issues of relative value. So I don't think there's an easy answer for it other than if you want to get ownership in the right places, you have to have written agreements. And if you want to avoid blowing patent rights, you have to have confidentiality. And you have to watch out for the people who are under incompatible obligations to their current employers. It's just a number of startups just sort of give up, I think, on getting intellectual property in the early stages. And then they may have to work their way through some ownership backwards in the future. There's not, I'm sorry, but it's not.
That's all the time we have
Okay.
for. Let's thank Stephen Johnson for his. If you're interested in picking up a copy of his book,